day off yesterday and I thought I'll get up at 10, lay around watching telly, eat about 300 grams of pasta for lunch, sleep in the afternoon. 6 a.m, my eyes opened wider than a Sondong cave, and after about an hour, I stopped lying to myself that I was going to fall back to sleep. I got up, had some breakfast, Netflix, rerun of Breaking Bad. And about an hour later, I got a text from my mum. It was just her postcode. She does that when I haven't popped in for a couple of days. Anyway, I went to see them, got the rundown on life in the slow lane, lunch, back home. By now, I'd lost the Netflix thread, so I thought I'd read something. Because I lead a really exciting life, the only magazine I had to hand was a law one. And I've read a couple of cases on contested wills. I'm Nino Cuffaro, I'm a solicitor, and this is Talk Legal with Nino. Now, the cases I read got me thinking about why there are so many contested probate cases over really silly things. And I don't mean people who litigate. There are so many people out there who love a ding-dong, or they've not been provided for when they really should have been. I'm talking about wills that are so poorly drafted that it just begs someone to contest it. And then, of course, there's all those without wills. And, well, I'm just not going to get into that today. So, typos, errors. And for the record, I lay the blame equally between the client and solicitor here. The solicitor's responsible for drafting the will, but name spelt wrongly. I mean, read it before you sign it. And then there's people left out. I'm dealing with a case at the moment where someone claims to have been accidentally left out of the will. Dad just forgot to put their name in it. He didn't forget. He just didn't leave you anything. But had there been an exclusion clause in the will, this particular case wouldn't have even got out the starting blocks. Then there's the classic where you own a property jointly with your spouse. You can't give your share to someone else in your will because you both own 100% of it. You die, the other person takes it. It's called survivorship. So if you want to leave your property to someone else, say your children or maybe children from a previous marriage, you have to change the ownership of your property from joint tenants to tenants in common. It's called severance. Don't worry about how you do that for now, but essentially it just means you're splitting the ownership and you each own a defined share now, which you can leave to your children. Now, I've seen wills leaving a share of the person's property to their children, but no severance on the property. You die, he gets a lot, rather than your children getting anything. It's now going to his new girlfriend. Now, if that's you and whoever made the will had legal advice, that's on the lawyer. If they didn't, well, I've done a video on what happens when you do stuff on the cheap. And then there's people for whom English isn't their first language. In fact, they don't really speak English at all. Now, you can still have an English will if English isn't your first language, but if you don't refer to that in the will and maybe have a translator present, you know where this is going, right? Bottom line, small, simple, unforgivable errors crop up in wills all the time. Where nobody tries to contest it, no one will ever know. But do you want to leave that to chance? I mean, if you're not using a solicitor because you want to save money, just think about how much litigation costs later on. Then double it, add VAT. That's the potential cost of saving a few quid. So if you like that, hit the thumbs up, subscribe for more videos on legal stuff, what to do on your day off. And when you subscribe, don't forget to hit the notification bar.